Good evening. This is John Milburn. This is Laws 12067, Environmental Law. We're up to week 8, and this week we continue our discussions talking tonight about protection of biodiversity and climate change. That covers an enormous area of work and law. In your text, covers chapters 11, 12, 13 through to 16. I've prescribed reading of 11, 12, 13, 16, but also chapters 14 and 15 are relevant. It also caters for problems 17, 18 and 19, and we'll have a brief discussion about those things tonight. I'd like to talk briefly about the examination, talk about the second assessment piece, which is on top of us already, even though you've just recovered your breath, more than likely from lodging the first assessment. Lo and behold, the second is due in 2 weeks' time. So let's start talking about the exam briefly. The exam is open book, and when we say open book, we really mean open book. The only things you can't take in effectively a standard dictionary. You can't take in anything which will allow you to connect to the internet. But other than that, if you think you know the answers to any particular questions, you can take in a written answer ready to rewrite in the examination. I apologise that the nature of an invigilated examination is a little antiquated, a little old-fashioned, in that we have to handwrite, and I do apologise for that. So it's quite a task. I appreciate that. Now, the structure of the exam is that you will be given an exam booklet, ask for a second one if you wish. It will be in 2 parts, Part A, Part B. Now, Part A is worth 20 marks. It's a compulsory question. It's a single question, and it's essentially a problem-solving type question. Those of you who've had subjects with me in the past will know that I like to ask questions as if you're it's in your first week in a law firm and you're confronted with a certain issue, or in a government department, or in the work environment. And so that's what Part A is all about. You'll be given a scenario. You'll be asked to act in an advisory capacity to deal with an issue that's hypothetical but based on real life. That's worth 20 marks. That's compulsory. Now, Part B is 30 marks, and students are asked to answer 3 of 5 questions. So you'll have some choice there. Each one of the 3 is worth 10 marks. Obviously, don't answer more than 3. If you do answer more than 3, I'll mark the first 3 that come up on the book. And the Part B are really essay-style questions. So if you look at previous exams, you'll get an idea of what's in Part B. Part A is something which is a little different to what has featured in past exams. If there are any questions about the examination, please let me know. In general terms, I'll try to assist. What I can say is that the examination questions will cover the entire ambit of the course. I'm sorry, that means a lot of reading to do, but they are essay-style questions. And you may get an idea from where we've emphasised certain parts of the course where those questions may lie. All right, so that's the examination, and I'm not sure the exam timetable is out. I think it might be. So have a look for that. And at this stage, make sure that you know when the exam is on, and make sure you know where to go to complete that examination. Those sorts of things happen outside of my control, in a sense. In a very real sense, they do. Okay, so that's the examination. I will talk about the second assessment piece tonight briefly, but before we do that, I'd like to discuss the problems for week 8 as they appear in the course outline, which is problems 17, 18 and 19. Now, these problems are designed to tease out some responses, some comments in relation to climate change and sustainable development, biodiversity and offsets. So I'm interested for your thoughts about the questions. I'm interested to hear your comments. And please feel free to join in live and make a comment, add a comment through the chat facility if you like. The first one, 17, says, it's a quote from the Honourable Justice Preston in relation to climate change and environmental litigation from 2011. So courts have no function directly requiring societal adaptation to climate change or mitigation of impact. Courts are not legislative rule makers or general administrative policy makers. Any role courts play in relation to climate change will be indirect and as a consequence of exercising functions vested in them to adjudicate disputes. It goes to the heart of separation of powers, His Honour's comments. So the question really is, what are the strengths and the limitations of the judicial role in responding to pressures of climate change? Are there any thoughts as to what are the strengths and limitations of the judicial role in responding to societal pressure, economic pressure, scientific pressure to do with climate change? If you have any thoughts, please feel free to come in and join live or make a comment on the chat facility and I can broadcast that. Well, perhaps to get you started, it would seem to me that the nature of the question is such as to have you think about the legitimate line that is to be drawn between the role of the courts in interpreting statutes, maybe judicial review, maybe merits appeals, as against the illegitimate role of courts in policy making. So courts have a role to play in interpreting statutes, of course, judicial review, merits reviews, and we've talked about that throughout the course. However, just to get you thinking more about the role of courts and say in my case tribunals where I deal with merits reviews and VCAT, in planning and environment sense, deals with merits reviews as well. The lines can be blurred because when you're dealing with an issue of climate change in the context of a merits appeal, then the decision maker, the Planning and Environment Court, for example, is the substitute decision maker in somewhat of an administrative sense. So there may be issues to do with wind farms or applications for coal mines, etc., which beg consideration of questions to do with climate change, and in that sense, in a merits review, the courts have some degree of involvement. Issues to do with coastal zones and inundation, coastal inundation, is another area where we expect that the courts may have a role through that merits review process. I'd like to have you think about the issue of adaptive management, which is where conditions are set as part of a development consent for projects at risk for climate-induced effects like coastal inundation. So have a look at that concept of adaptive management in that sense. All right, so the judiciary is able to interpret the law. That is a limitation. Thank you, Michelle. And if you come up with any other thoughts collectively, please let me know. I might move on to problem 18, which deals with biodiversity. The question is, biodiversity should be a fundamental consideration in decision making. How does the law promote this? Have the courts, as decision makers in merits appeals, responded to this challenge? So once again, we're dealing with the issue of merits appeals in the context of biodiversity. I mean, it would seem to me that legislation has given no clear guidance on how biodiversity is fundamental to decision making, which is a bit odd given that the key piece of Commonwealth legislation is the Environment Protection and Biodiversity Conservation Act, and we'll be talking about that tonight in more detail. But that statement, does it mean that decision makers, and I'm talking administrators and courts, are they required to give priority to biodiversity? Yet, if that is the case, how do you reconcile that fact with the reality that we have legislation that separately deals with threatened species and native vegetation? So legislation has been drawn to draw a distinction between, say, threatened species and native vegetation from biodiversity generally. And I guess in answering the question, you might think, is that a legitimate approach? And does it mean that some biodiversity is more important, more fundamental than others? I mean, Is it appropriate that threatened species and ecosystems are treated in a different way to biodiversity generally? I appreciate I'm not getting a lot of answers. I'm just trying to tease out some thoughts that you may consider in response to that question.
Now, can I say something?
Yes, Tony.
I don't think, just from my experience, like the EPBC Act and all those other, like the Queensland SPA and all that, they're just that some people might take the assumption that, you know, it's the government trying to be seen to be doing something, you know, but I think 9 out of 10 projects, you know, the DAs that go in, you know, that have a, get referred to EPBC and the EPA and that, they go ahead. They just work around, you know, they just put conditions on it. Like, for instance, in the electricity industry, if there's a threatened species or something, they'll just move the line and go around it, or they'll relocate the, well, you know, that's the way they do it, because at the end of the day...
Sorry, it's a legitimate approach, yeah.
Yeah, and it's just there so everyone wins, I suppose, in the grand scheme of things. But I don't think it's there designed to stop projects from going ahead. It's there to, you know, to make them compliant. But, you know, I don't know what others think.
Are there any other thoughts? Thank you for that, Tony. Well, I guess also it begs the question about the involvement or the application of the precautionary principle in the way developers need to perhaps explain or justify the impacts of a particular development on biodiversity. All right, so what I'm really asking you to do there is think about biodiversity generally, think about how the courts may treat it, think about, is one part of biodiversity more important than others? Tony's put in some valuable feedback in terms of, well, just deal with the problem in a more, more practical or commercial way. So there are a few issues there that you can consider in dealing with that question. And Shane's made a comment, everyone wins. It doesn't seem correct with the adversarial nature of law. And that's true, particularly in environmental law, the adversarial approach, as opposed to an inquisitorial approach, may be seen as inappropriate. Just a thought. Let's have a look at problem 19, which deals with offsets. This is a quote from D. Robinson, Strategic Planning for Biodiversity, New South Wales. The claim that overall biodiversity values can be maintained or improved in a system based on gradually eroding the stock of patches of ruminant vegetation has a rhetorical element and is counterintuitive. So the question really is offsetting really a way of relaxing planning controls to allow developers to do what they would otherwise not be allowed to do? And how does or can the law ensure that offsetting truly is a last resort? Even then, is it possible to improve or maintain biodiversity values by offsetting? Okay, so if you have any thoughts in relation to that, please let me know. So what we're really doing here is identifying the reality of the fact that offsets are becoming more and more commonplace, I guess. And the question really is aimed at asking you to consider whether the offset regime is entirely legitimate. Legitimate, I guess, from a scientific point of view, from an environmental perspective generally. Is it really used as a last resort? So I'm making the statement there that offsets should be used as a last resort. But is it really a legitimate way to go? Or is it just a way of dealing with economic issues in the context of planning? And is there an argument to suggest that offsetting is simply a way of allowing a developer to gain a short-term gain at the expense of longer-term cost to the environment? And is it legitimate at all? I mean, if we're at a stage where offsets are required, should decision makers simply refuse consent to an unacceptable development? In other words, is offsetting just a way of permitting a development that should really otherwise be refused? And can conditions be imposed through, again, I'll use adaptive management, to ameliorate possible complications in the future? I mean, but if you do have conditions long-term through adaptive management, I mean, when is the condition triggered? How does the need arise? How is it monitored? How is it enforced? So there are so many issues. And really the purpose of that relatively simple question is to have you think about those issues and consider how you would respond if called upon to do so in a more general sense. Okay, so are there any questions arising from that? No further comments, just a general agreement of concerns relating to offsets. Okay. All right, let's now have a look at the commentary for this week and perhaps expand on that commentary to some degree. And I'm talking about the week 8 notes. You would have seen that in some ways we're going back to the beginning by making reference to the role of international law and federal law in the context of protection of biodiversity and climate change. And it's an important aspect to it. And it does follow on from the discussions that we had last week with Phil Jeston in terms of the environmental impact assessment regime. Now, if you can bear with me, what I would like to do is talk about, here we go, now I'm right. As you know, it's the Convention on Biological Diversity, which essentially is the starting point for discussions with respect to protection of biodiversity. That's the Earth Summit from Rio 1992. So have a look at that, do some reading about it. And signatory nations, Australia is a signatory nation, are obliged to establish systems for conservation of biological diversity. So the EPBCA is the key piece of legislation, of course, that reflects the international obligations of Australia in its legislative form at a Commonwealth level. And in particular, have a look at, we might even call this up on the screen, Chapter 5 of the EPBCA. So if you've got it in hard copy, have a look at that. If not, you might want to call it up on the screen for yourself. And I'm just getting rid of some documents here so that we can do that now. All right, I'll share the screen. All right, so hopefully you can now see my screen and Commonwealth legislation. Just give me a, yeah, that's okay. All right, so EPBCA, it's a very substantial piece of legislation. Now, Chapter 5 of the EPBCA, which deals with the issue of the Commonwealth conservation of biodiversity and heritage, encompasses sections 107D all the way through to 390 SM. And the way the Commonwealth enumerates its legislation can be very confusing with lots and lots of sub-headings. So sorry to be scanning so quickly down the page, but from section 107, we go through to dealing with biodiversity. What I'd like to do is have a look at section 171.3, might be a good starting point. And that's the manner in which the components of biological diversity are identified in the Act. Subsection 3 actually says species, habitats, ecological communities, genes, ecosystem and ecological processes. Now, importantly, for the purposes of the section, there is specific reference to those matters set out in Annex 1 to the Biodiversity Convention. Now, that convention is the 1992 convention, as amended from time to time, the Convention on Biological Diversity, the Rio Earth Summit So that's perhaps the starting point for our discussion about biodiversity conservation in the context of the federal government. Another area of the EPBCA that is important is that which relates to Commonwealth Reserves. So if we look at section 344 and 345, and I'll just pan down to that, sorry, I'm getting there. Here we are. These are Commonwealth Reserves, is Division 4 of the Act. Section 344 enables the Governor-General or a board to, or the Governor-General to declare an area of land or sea as a Commonwealth Reserve. If we go to the next section, 345, there's a note about the extent to which the Commonwealth Reserve can be created, and section 366 goes on to deal with the obligation on the director or a board for a Commonwealth Reserve to prepare a management plan for each Commonwealth Reserve. So there's some of the key sections that you might want to consider as you're working your way through the EPBCA and discussions about biodiversity conservation. Look, I guess the other important piece of legislation at a Commonwealth level is the Great Barrier Reef Marine Park Act, and that is 1975. I recommend you have a look at that. The main object, which is set out in section 2A, is essentially to provide for long-term protection, conservation of the environment, biodiversity and heritage values of the Great Barrier Reef region. If we look at section 3AB, it sets out the principles of ecologically sustainable use as relevant to the Great Barrier Reef Marine Park. And we see some familiar names and concepts, including decision-making that deals with the long term as well as the short term, the precautionary principle, intergenerational equity, conservation of biodiversity, ecological integrity, and improved valuation, pricing and incentives. So a lot of common factors, as we've seen in previous legislation and discussions throughout the course. Also relevant is section 31 of the Act, which deals with the areas part of the marine park. And you'll see that as soon as practicable, after an area has been declared under 31 to be a marine park, the authority, that is the Great Barrier Reef Marine Park Authority, must prepare a zoning plan with respect to the area, and that is section 32A of the Act. So that's the requirement to prepare a zoning plan with respect to the area. And that goes on to provide a number of, I suppose, rights and remedies. Just in terms of dealing with coastal issues, bear in mind it's not just the Commonwealth that has a role to play in that regard, but the states also have a role to play. And in particular, from a state level, I'm just making my way eventually there. No, I won't even try. The Coastal Protection and Management Act of 1995 is an issue of concern. Look, I will actually go and deal with another issue, and that is the issue of Queensland, the Environment Protection Act, and that's got, the Environmental Protection Act has a number of issues that relate to biodiversity and protection, conservation. If I could just highlight a few points. Firstly, section 22, the Act binds all persons. That means that the Commonwealth and other states are bound to the extent that Parliament permits. Now, importantly, from a compliance and enforcement perspective, section 24 of the Act sets out the statutory rights and remedies of that the Environmental Protection Act creates, and they're in addition to, not in substitution of, but in addition to civil rights and remedies at common law or sourced in other statutes. In addition to imposing, I suppose, penalties in a general sense, there is also the fact of criminal sanction in relation to a breach of the Environment Protection Act. And if I could refer you to section 319 of the Act. 319 provides for a general environmental duty, and a breach of that obligation could expose a person to a restraint order or a statutory injunction, and that could be under section 505 of the Act. I'll just highlight that. So that's the statutory injunction or restraint of contravention provision, or alternatively, an action at common law. Now, you can understand that if you were confronted with a situation where a client comes to you and says, look, I wish to complain about a contravention of a general environmental duty, then you may trigger, that may prompt you to start looking at these specific provisions. But more than likely, people won't be that specific. They'll simply outline a scenario and you'll be asked to consider the various options that might be available. So the point that I'm making tonight is that in the context of issues to do with protection of biodiversity and conservation, it is not just the Commonwealth legislation that may be relevant. The Environmental Protection Act may also be relevant and should be considered in that context as well. So have a look at section 319 for the general duty, consider section 505, and bear in mind what I mentioned before about section 24, which specifically states that the statutory rights and remedies is not exclusive, is not to take over or be in substitution of other civil rights or remedies under other statutes. So it's a really wide playing field that you may need to consider. Look, in the material, I've outlined a number of ways in which the Environmental Protection Act can be used by regulators to enforce issues to do with concern about environmental damage. Have a look at section 4371, for example, and 4371 provides for offence provisions in relation to the causing of serious environmental harm. 4372 says that potentially a person must not unlawfully cause serious environmental harm. So the first deals with willful and unlawful causing of harm. The second is less serious, and that is causing unlawful harm, not necessarily willfully. Section 492 of the Act is also relevant in this context, and section 492 deals with the issue of responsibility for acts or omissions of representatives. So if in a proceeding for an offence against the Act, it is relevant to prove a person's state of mind about a particular matter, it's enough to show that the act or omission was done or omitted to be done by a representative of the person within the scope of the person's actual or apparent authority, and the representative had the state of mind. So here we have an issue that deals with responsibility for the actions of others pursuant to section 492. Think about that particularly in the context of corporations or issues where there has been delegated authority. Now, in the context of corporations, also consider section 493, subsection 1, says that the executive officers of a corporation must ensure that the corporation complies with the Act. So if the corporation commits an offence, each of the executive officers also commits an offence. That is, subsection 2, failing to ensure that the corporation complies with the Act. Now, bear in mind that subsection 3 states that it is a defence for an executive officer to, or subsection 4 rather, to prove that the officer was in a position of influence and took all reasonable steps to ensure the corporation complied, or the officer was not in a position of influence to influence the conduct of the corporation. So if you're in a law firm and your corporate client comes to you and says, I have issues about personal liability in terms of what my corporation has done, which is alleged to have caused environmental harm, you would certainly need to consider those sorts of representative issues and provisions. Now, if there are any questions about that, please let me know. But what I might do is, while I'm still in the state legislation, what I intended to do before was refer you to the coastal management provisions. So that's the Coastal Protection and Management Act 1995. And have a look at Section 3. These objects dovetail in at a state level with the obligations imposed under the EPBCA and the Great Barrier Reef Marine Park Act. So Section 3, always a good place to start looking at the objects of an act. And I'll also refer to Section 4 of the Act, which is, okay, well, how are these objects going to be implemented? As was the case with the Environmental Protection Act, Section 19 says the Act binds all persons. So keep that in mind as well. And once again, similarly to the other legislation that we've talked about tonight at a federal level, in this state jurisdiction, the Minister must prepare a coastal plan for the coastal zone. And bear in mind that the state is responsible for the area out to 3 kilometres, and then the federal government takes control from 3 kilometres out to, I think it's 20 kilometres is the outer limit. Okay, again, sorry, while I'm on the state jurisdiction, other appropriate legislation to consider would be the Vegetation Management Act. That was an act amended in 2013, and we'll just have a look at the Vegetation Management Act, 1999, but amended substantially in 2013. Once again, have a look at the purposes of the Act, Section 3, and you'll see that amongst other things, the requirement is to conserve vegetation, prevent loss of biodiversity, maintain ecological process, etc. IDAS is relevant to the process. Have a look at subsection 2, where the purpose is achieved, amongst other things, through the use of Codes for Planning Act and, in particular, applications under IDAS. Section 6 of the Act deals with issues to do with binding all persons, as was the case previously. And Section 10 means that the Minister is required to prepare a vegetation management policy for the whole state. So you'll see that there's, what I'm trying to emphasise amongst other things, is there's a common approach here. You'll see that there's the purpose of the objects, there's the way in which the purpose of the objects are to be achieved, and there's commentary in relation to who is bound by the Act and what policy requirements must be fulfilled for ministers and others to undertake their responsibilities appropriately. If we just go back to the to the Act, Section 22A is worthy of comment, and that is a comment that deals with clearing applications for particular vegetation requires certain assessments to be undertaken, and the Chief Executive may refuse or must refuse an application in certain circumstances. So there were substantial amendments in 2004. I've mentioned these substantial amendments in 2013, and the 2004 amendments meant that the government provided for a $150 million compensation program as part of the, I suppose, the incentive for this act to go through relatively smoothly. And just briefly, and I know I'm doing a lot of talking, I'm sorry, but I'm just keen to refer you to other pieces of state legislation that are important in the context of biodiversity conservation. I think the Heritage Act, Queensland, 1992. Where is it? No, I've lost it. Oh, the Queensland Heritage Act. Queensland Heritage Act, 92. That's important. Have a look at sections, say, 31, which deals with the Queensland Heritage Register. That's important from the perspective of conveyancing as well. And I think I've uploaded a video which deals with my take on specialist searches that should be undertaken by a conveyancer in the context of environmental conveyancing. So section 31.2 is worth having a look at. Section 68.2 might be worth having a look at too. It's to deal with assessing developments under the Planning Act. Just a word, it says the Planning Act, it doesn't say the Sustainable Planning Act. And the reason for that is that many of these pieces of legislation have in the definition what is meant by the Planning Act. So I'm not sure if I'll be able to make this work. I'll probably not be able to find it, but if I can find the definitions section, my guess is that it will say that the Planning Act means the Planning Act as it is defined at a particular time. So if we go down to Planning Act, where is it? Planning Act means the Sustainable Planning Act 2009. Now that will change soon. Unfortunately, if you're doing this course at the tail end of the Sustainable Planning Act's life, the key piece of legislation by the end of this year almost certainly will be called the Planning Act, and it will supersede the Sustainable Planning Act. So my hope is that that doesn't happen right on the exam, but it might, so sorry. Okay, so the Heritage Act is important, and I think that is getting pretty close to where I should leave it. Or maybe I should mention the Mineral Resources Act. So if we go back to Mineral Resources Act, 1989, again, have a look at the objects, have a look at the obligations on the Chief Executive in granting permits or prospective mining claims, prospecting permits, etc. The key sections, if you're keen to look at it, would be sections, say, 29, 24. So 24, granting of a prospecting permit. 29, the term of the prospecting permit. Section 74 deals with certain requirements for the minister to deal with mining claims. Section 77 deals with the land court hearing. You remember back to the commentary we had with Sean Ryan, who talked about the land court's role in dealing with these sorts of issues. And I know I'm moving very fast, but these are really important sections in the context of mining and environmental law generally. So they deserve more comment than I'm actually giving to them. I apologise. Have a look at section 234, which deals with the ability of the minister to grant a mining lease, and section 260, which provides for objections to the application for granting of a mining lease. Again, Sean was talking about that in the context of objectors, generally speaking. And I look at section 269, which deals with the Land Court's recommendation on hearing. And a lot of these things are also relevant in the context of ADR procedures that we will talk about in week 11. Okay, we're getting close to our critique on finishing. A couple of more pieces of legislation. In terms of fishing, there's the Fisheries Management Act, is worth considering. Well, the Fisheries Act, the Fisheries Management Act is Commonwealth, sorry. And then, of course, we have the Fisheries Act at a state level. And also at a state level, we have the Nature Conservation Act. There are so many pieces of legislation that you need to bear in mind in the context of environmental prosecution, litigation, and management generally. So again, if you're looking at an act, have a look at the objects, in this case, section 4 of the Act, for the Nature Conservation Act, and section 5, which deals with how the object is to be achieved. Very familiar process. Section 8, dealing with the nature of management, the meaning of nature, meaning, let's have a look, ecosystems, natural and physical resources, natural dynamic processes, and characteristics of places. And just finally, and I know I've been saying finally, but I really mean it this time, finally, in that particular act, I refer you to section 173D, which deals with enforcement. So you may have picked up a common theme here that I have talked a few times about the way in which you might go about enforcing issues to do with environmental degradation, loss of biodiversity, and bear in mind that the client won't come into you and say, would you be kind enough to explain the nature and effect of section 173D for me? The client will come in and you have to find these sections in amongst the myriad of other sections that may be relevant overall. Okay, so sorry that's been a little daunting. We haven't finished yet. I know I've been keeping you a long time tonight. If there are any questions, please feel free. The question is, while we have guest speakers, do you have videos discussing the problem questions? I haven't really done that, no. Any tips on how to work with all the relevant acts in a particular case? Where do you start? What's more important? Oh, that's a really good question. Because there are so many pieces of legislation, I guess the key Commonwealth legislation is EPBCA and at state level SPA. That's where I would start, Environmental Protection Act, and then from there you'd spin off to the specifics depending on the exact nature of the matter that is under consideration at that time. Okay, now I want to talk briefly about the second assignment, and the second assignment, I'll share the screen, requires you to have a look at the Ella Bay Integrated Resort Project, and I'll just do that now. Share screen, here we go. You should see that up on your screen now. So this is the requirement for the second assessment piece. And in that regard, you are required to, well, firstly, just provide a short summary of the whole project. That means I would look at the executive summaries, certainly the summary of the report for the Coordinator General, have a look at the executive summary for the EIS, have a look at the terms of reference, and perhaps some involvement about this being deemed a controlled action. Then you need to consider the statutory process. Now, I'm really talking more than just IDAS. I'm talking about the whole body of statutory processes that relate to the interplay between Commonwealth and state. So you certainly need to consider the approved bilateral agreement regime and the scheme of assessment under the EPBCA. Think about what Phil Jestins told us last week in the context of what you're required to do. You'll certainly need to brush up on your reading about controlled actions. Just remember that controlled action is an action that's referred to under Part 3 of the EPBCA, and you'll need to think about the involvement of the Coordinator General. How does the Coordinator General work through the Commonwealth in that bilateral agreement regime? So that part of the second assessment is designed to test your understanding of how it all fits together. Then, of course, is the environmental impact statement. Have a look at section 1.6 of the supplementary information, or the complete supplementary information to the EIS. So that's this document here. And if you go into 1.6, you'll see that it deals with socio-economic issues. So have a look at that in the context of the rental market and the proposed workers camp. Endangered Kasawari, well, I won't tell you exactly where that is. You'll have to find that and think about the strategies that have been put in place. And finally, think about the concurrence agencies and issues to do with non-compliance. In that regard, look at the full report of the Coordinator General, and in particular, consider Appendices 1, the stated conditions, and 3, the proponent's commitments, in the context of the answer that I require. All right, well, I'll just stop that share now. You've been very patient with me tonight. I'm sorry it's taken so long. We had a lot to work through, and I appreciate there's a lot of reading for tonight, but it's all very interesting. Now, are there any questions that I've glossed over or that we need to consider before I wrap it up for tonight? Thank you very much for everyone for submitting your first assessment piece. I think almost everybody's in now, so that's great. And I guess if you're watching this, you're doing so after you've already submitted it, so thank you.
John,
yes, Tony?
you've got to, with that Sustainable Planning Act, you've got to take into account too the Sustainable Planning Regulation.
Oh, that's a really good point, and it's often overlooked. Yes, the regulations are very important to consider. And in a few weeks' time, when we start talking about litigation, I'll be stressing the importance of the rules that apply, the Planning and Environment Court rules, the UCPPR, Uniform Civil Procedure rules. We've seen that's touched on in the first assessment, and practice directions. You're right, it's more than just the Act. You've got to look at the regulations and the rules as well. Thank you, Tony.
I think it's Schedule 3, isn't it?
That I do not know, sorry, but thank you. But thank you for that. Maybe that would be a good one for you, crew, if you spot it, Tony. And can I just say, I'm really impressed with the way that you have collectively supported each other and collaborated in a very positive and meaningful way throughout this course. And please continue. It's great to see. Really appreciate it. Okay. Well, we must be all just about drained tonight. You've done well. You've stayed with it. So unless there's any further questions, I might stop the recording now, and all the best and speak during the week.